The nature of law. The status of law is a complex and complicated concept that has been historically influenced by philosophy, theory, and legal analysis. It has many dimensions that help define its nature and role in society. Below are some important features of law. A. Legal process. Law provides the process of self-regulation of individuals, organizations, and government in society. Sets boundaries, sets standards, and writes rules to guide interactions and resolve conflicts. B. Health management. Law, as an instrument of social management, maintains order and stability through behavioral control and prevents conflict adjustment. It shows the unity, beliefs, and norms of a society and provides a way to solve natural problems that can achieve social harmony. C. Legislation and authority. The authority of laws comes from recognition by individuals and organizations. The formation of a law often depends on its source, whether derived from democratic processes, cultural history, or legal institutions. D. Services. Includes administrative procedures, including law, courts, police, and monitoring agencies. The ability to apply the law gives meaning to the law and ensures compliance. E. Complexity and diversity. The rule of law is distinct from the legal system, culture, and history. It includes various laws, doctrines, and principles that address a variety of issues, from personal rights to international studies. F. Flexibility and adaptability. Legislation changes according to people's needs and changes over time. Laws may be amended, repealed, or modified to adapt to new situations, technologies, and conceptions of justice. G. Interdisciplinary impact. Law deals with many disciplines, including justice, philosophy, economics, science, and culture. These intersections shape the legal structure and interpretation of law in practice. H. Protection of law. Law generally protects human rights and ensures fairness, equality, and fairness. Establishes procedures for resolving disputes and disagreements in accordance with the appropriate procedure. I. Challenges and criticisms. The rule of law is not without its challenges. Debates have arisen over the relationship between law and morality, the balance between individual rights and social interests, and the possibility of unjust laws or torture. J. Globalization and international law. In the international interaction environment, international law refers to issues that transcend national borders, such as politics, trade, human rights, and environmental protection. Is law territorial in nature? Yes, law is territorial in nature. Refers to the principle that law and the application of law are generally limited to a particular area or jurisdiction. This concept is an important part of how the law is structured and implemented. Here is an explanation of why laws are considered territorial. 1. Territorial. Laws are created and enforced in a specific area by the government or police. These boundaries include countries, states, provinces, or other jurisdictions. Each jurisdiction has its own laws that govern conduct and interactions within that jurisdiction. These laws are designed to address the specific needs, values, and conditions of the people living in the area. 2. Sovereignty. The concept of sovereignty is important in understanding why law is territory. Each sovereign entity, usually a nation-state, has ultimate authority to make, interpret, and apply laws within its territory. This means that the laws of one jurisdiction are not binding on individuals or entities in other jurisdictions. Sovereignty is based on the principle that law is exclusive and exclusive in any given territory. 3. Action. Policy is not just a theoretical concept, they want political rights. In some jurisdictions, administration is done by authorities, courts, and other relevant institutions. These organizations have jurisdiction only in designated areas. This limitation of control ensures that the law is applied consistently and effectively in the specific area for which it is intended. Conflicts of rights. Conflicts of rights may arise when individuals or businesses share different rights. These conflicts arise when different jurisdictions have conflicting laws or different rules for a particular situation. For example, a contract may be legally enforceable in one jurisdiction but not in another. Solving these problems often requires careful consideration of legal standards, international agreements, and the specific circumstances involved. 5. Extraterritorial application. Although most laws are regional in nature, some may have extraterritorial impact. This means that certain laws may apply in certain situations to practices or persons outside the law's jurisdiction. For example, a country may impose sanctions on foreign organizations that affect their international activities. However, the enforcement of foreign laws is often subject to international laws and agreements to prevent unlawful interference in the affairs of other countries. 6. International law. International law operates differently from domestic law. Involves the interaction of sovereign states with international organizations and people. Although international law cannot replace national legal systems, it regulates matters that transcend national borders, such as trade, commerce, human rights, and environmental protection. International law is based on treaties, agreements, conventions, and customs that are said to be accepted voluntarily.